Hello, law nerds. It is Monday. It is December 18th. It is a unexpected ride, but sometimes we ride. Replay crew, love you. All the timestamps will be down below. I have the court footage from Ruby Franke's hearing today in court. So we are going to watch that footage. It was not live streamed. It was a very short plea hearing. We're going to talk about her lawyer's statement. Then we're going to go to the court footage. Then we're going to go to Q&A. That's what we're covering today. She did plead guilty to 4 counts. She will be back in court for sentencing in February. Her co-defendant, Jody Hildebrand, will be in court on December 27th for the same type of hearing. So are you guys ready to roll? Law nerds, I've got you. I think this is the first place on the internet you can find this footage unless somebody's released something on Twitter that I haven't seen yet. So you know what? We're here. Let's go.
Hey there. I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right. On Friday, Ruby Franke, the mom vlogger from the 8 Passengers channel that's now down, was we knew that she was going to be going into court for a waiver hearing. A waiver hearing can just be waiving the preliminary hearing, but her lawyers released a statement making it very clear that when she came into court today, she was going to be taking a plea deal. What a plea deal means is that she's going to be pleading to something less than everything she's charged to, generally with a negotiated agreement with the state, meaning the amount of time that she will be serving is negotiated between the defense and the prosecution, and they agree that the case is not going to go to trial and that the case is going to resolve. That generally means a certain number of the charges are dropped, and she is charged with 6 counts of aggravated child abuse, 3 counts for each victim, the victims being her minor children. I am not going to get into the details of the different charges. I've done that in other content on the Emily Show podcast. So her law firm, Winward Law, made this statement. We're going to go take a look at that real quick, and then we're going to go to court. Or should we? Yes, we're going to do this very, very, very briefly. So, Emily, share your screen. There we go. Winward Law is making a statement on behalf of Ruby Franke regarding the pending charges in Washington County 5th District, along with her thoughts about her current family situation. Our client is working with the prosecutor's office and anticipates resolving this matter quickly by entering a plea agreement with the court on Monday, December 18th. What we are going to do is go to court, and then we will come back to the rest of this statement. There's a little bit more here to parse. I've got thoughts, but what I know you want to see is the hearing and see Ruby Franke coming into court in handcuffs. I think that's what most of you are here for, and we're going to do that right now. So let me go ahead and share my screen, and we're going to go to that court hearing provided by me. So thank you to the Pool Media Company, which was, I believe, KUTV, who provided this because they are amazing. So let us go into court now. I'm going to make myself a little bit smaller, and we will do that. So let us go. Let's see what happens in court.
Good morning. Welcome to District Court. We're here in the matter of State of Utah, Franke, case number 231501764.
Things happen.
Mr. Winward is here representing Ms. Franke. Let's bring her out.
And again, this hearing is from this morning in Utah, less than an hour ago. This was not allowed to be streamed. This was not allowed to be, it was only allowed to be recorded by one pool camera, and that's what we have here.
And Mr. Clark and Mr. Shum
This is
are
Judge
here
Walton
representing the state of Utah. Ms. Franke is now here.
Ruby Franke was looking back into court and smiling. Her family, or some of her family, was in court today. I did not see Kevin Franke walking into court. He has filed for divorce, but that's Ruby Franke.
Mr. Winward, we are scheduled for a waiver hearing. Is there going to be a waiver today?
This is her defense attorney?
There will, plus a plea agreement, Your Honor.
All right.
I'll ask the bailiff to hand you if it's been executed.
All right. Mr. Winward.
I don't know how she's making her hair wavy in custody. They don't have a heat styling, so unless she's wrapping her hair around a sock, I'm not quite sure how she is prepping the hairdo for court, because heat styling in custody is not a thing.
You have discussed with Ms. Franke a preliminary hearing, what's involved in a preliminary hearing. She understands she has a right to a preliminary hearing on all of the charges in the case. She understands what the charges are, and she's prepared to waive a preliminary hearing in the case on all charges.
She is, and that is contained in this agreement on page 7 as well.
The judge is making clear to the defense attorney that she is going to be waiving the preliminary hearing, and the preliminary hearing is going to be waived. I speculated when we had gotten 3 months on without a preliminary hearing that they might be working on a plea deal. We'll talk about that after this hearing.
Very good. All right, I've been handed a plea agreement, and it appears to be signed by Ms. Franke. Ms. Franke, did you sign this agreement?
Yes,
And you did that today? When did you sign it?
on the 18th,
Okay.
Today.
You've read it carefully?
She signed it today.
every word.
Your signature represents to the court that you've read it carefully, that you understand what you've read, and that you agree to all of the terms. Is that all accurate?
Yes,
You've had sufficient time to ask questions of your counsel, to go over any questions you have. You're ready to go forward.
yes,
You don't need any more time.
I'm ready.
In case you missed it, that was the court taking all of the waivers for the plea deal. Those were all of the waivers that need to be taken by the defendant. Have you had enough time? Have you talked to your lawyer? Those are the waivers. That's it.
Ms. Franke, is anyone pressuring you to enter into this agreement?
No,
Anyone promising you anything I haven't been told about?
no,
These are
Anything
the
that's not in the
standard
written plea
waivers.
agreement?
no,
Are you under the influence of alcohol or drugs today?
no,
Is there anything today that could in any way interfere with your ability to understand the agreement, its consequences, anything?
no,
No physical condition, no medication, nothing?
no.
The feed is a little
For
bit
the record,
blurry.
counsel?
No, Your Honor.
So they handed the written plea agreement up to the court. The court read the written plea agreement to themselves. They've not read that in court. The court then read all of the waivers. Those were her waivers. We will see what happens next, which is going to be a plea, but that's why this hearing is so short. She came in, she waived her prelim. She is waiving all of her rights at the moment and agreeing to the plea agreement that has been written.
Mr. Winward, we ready to proceed?
We are ready to proceed.
All the waivers are
All
done.
right, then. Ms. Franke, how do you plead to count 1, aggravated child abuse, a second-degree felony?
Guilty,
To count 3, aggravated child abuse, a second-degree felony?
guilty,
To count 5, aggravated child abuse, a second-degree felony?
guilty,
And to count 6, aggravated child abuse, a second-degree felony?
with my deepest regret and sorrow for my family and my children, guilty.
Ma'am, now is not the time to make a statement. Though she did make a statement that with her deepest regret and sorrow to her family, she has pled guilty to 4 counts, 2 for each victim. Her victims are her children. We are going to go over what each of those aggravated child abuse counts were, but she pled to count 1 and 3, 5 and 6, and decided that instead of just saying guilty, she also needed to say that it is with her deepest regret that she pleads guilty.
There is a factual basis set forth in the agreement that is a stipulated factual basis, counsel.
That's correct, Your Honor.
I'll be interested to see if any of this gets read into the record, but a stipulated factual basis means that she is agreeing to the truth of the facts of what happened. We saw Creighton Waters in the Murdaugh plea go on at length about the factual basis. That is in the written agreement that has been signed that the court has. So there are agreed upon facts where she is not just pleading guilty to the charges, but admitting the underlying facts of what happened.
That is correct, Judge Walton.
The court finds that the factual basis is sufficient. All of the terms of the agreement are stipulated, including that the court obtain a pre-sentence investigation report, correct?
Correct.
Well, that's why the sentencing is going over to February, so there's time to complete the PSR.
There won't be any argument about whether prison is the appropriate sentence, and there's an agreement about the 4 counts running consecutive.
That is correct.
What they didn't say is how much time she will be getting on the 4 counts, but she will be doing 4 counts consecutive, which means after each other. So she is going to be getting some prison time, and that is why they are doing the pre-sentencing report, so that they have all of the information to send her to whichever prison facility she is going to, but that will be consecutive time. How much time? It could be 5 years on each count. It could be 1 year on each count. It could be 2 years on each count. The maximum is 15 years on the counts. This is a first offense in that it is the first time she has been charged with this. So she will be getting her time stacked, and we will see how much time she will get stacked.
All right, the court finds then that Ms. Franke's pleas are made knowingly and voluntarily. The court therefore accepts and enters those pleas.
Those pleas are entered formally.
The court orders the preparation of a pre-sentence investigation report to be prepared by AP&P and the Department of Corrections. Counsel, what about sentencing on February 20th? I think, do you and your client agree to waive time, counsel?
We do agree to waive time, Your Honor.
February 20th, I believe, is a Tuesday. Is that right?
She will be sentenced February 20th. I doubt that they will do impact statements.
10 a.m.?
That works for us, Your Honor.
The
All
state
right.
might make a statement.
Anything else for today?
Your Honor, maybe, I've heard the court say this several times in a different fashion. We are not binding the court to any specific sentence, and the court retains its right to sentence as it sees fit.
Well, that's new information. They've agreed to the 4 counts. They've agreed that those counts will be consecutive, but it does not look like they've agreed on the amount of time. That is a very interesting quirk. This makes that pre-sentencing report or pre-sentencing investigative report much, much more interesting. Oh, that is interesting. I rewound. We're going to listen to that again. Wait, no, embiggen. There we go.
10 a.m.?
That works for us, Your Honor.
That's very interesting. I've got a lot of thoughts, folks.
Anything else for today?
Your Honor, maybe, I've heard the court say this several times in a different fashion. We are not binding the court to any specific sentence, and the court retains its right to sentence as it sees fit. I just mentioned that this is not a Rule 11 plea, but although it's a stipulated statement of defendant.
Counsel approach, please.
The court also has some questions. It would seem the court's like, excuse me, what? That is a very, very interesting thing. So she has pled to 4 counts. The state has agreed to dismiss 2 counts. The court is not bound to a particular sentence, but they have agreed that whatever sentence is issued will be consecutive, which means plus, not at the same time. You can run 4 counts all at the same time. And then if you get, 30 years plus 30 years plus 30 years plus 30 years, then it all runs at the same time and it's 30 years, not 100 and whatever that would be. So that's very interesting. I'm saving your guys' questions till we get to questions.
Thank you, Your Honor.
Thank you. We are in recess.
Thanks, Your Honor.
And that is the entire plea hearing. We're going to watch as Ruby Franke leaves the courtroom. She looked towards, it looks like whoever this is in the audience is who she looked towards sitting. Whoever this is sitting back here in the audience is who she looked toward as she was leaving the court again.
Nothing from the state.
Thank you, Your Honor.
Thank you. We are in recess.
And that is the end of this hearing. This is very common for plea hearings to go this quickly. We've watched a lot of cases that are very protracted. This is very common. And that's it. The end. So for the chatter looks like her sisters. Fair enough. We're going to get to some questions. I'm going to pull up the charging documents again so we can go through what counts she has pled to, what counts have been dropped. But let's go ahead real quick and recap. Not that you need it, but for those of you just coming in, and then we'll see if we need to play the hearing again at the end of the stream. It was real short. Ruby Franke pled guilty to 4 counts. She said that she was sorry to her family. We can go back through and watch her statement before her final guilty plea. 2 counts out of the charging document, therefore, were dropped. The court is not bound to a particular sentence. However, the court has said any sentencing will be consecutive, meaning they will add together. So it will be whatever the sentence is for count 1 and count 3 and count 5 and count 6, those will stack together and be added. So she has pled guilty. I saw a number of you ask in the chat, and I think they are good questions. A number of you ask in the chat, how is it a plea deal? Carla said, how is it a plea deal if there's nothing she's getting out of it? I think Ruby Franke has gained a tremendous amount from this plea deal. One, if she cares, which one would hope that she would, her children will not have to testify against their mother. She will not have to sit through a preliminary hearing. She will not have every detail of everything the state has found and alleged and all of the documentation that they've gathered become public information. She is getting to, one would hope, protect her children so they're not testifying. And she got 2 charges dropped, and this does not become public. She will not be hearing all of the evidence against her and all of the testimony against her in a public form. So I think there is benefit here, but I have also seen cases where defendants are like, can we just not waste another year or 2 in jail and just start my sentence and go? And they will plead open to the court. Your Honor, I plead open. I plead guilty open to everything that I'm charged. Like, you sentence me to what you're sentencing me to. So that is not uncommon. Sue M asked, can a judge deny a plea deal? Yes, judges can absolutely deny plea deals. They didn't do that here. Cherry in the chat said, retired PSI writer here. I know what I would recommend. And I'm sure the information that's been made public, there is substantially more information than that. So hopefully that helps. We're going to take a look at the charging document. We're going to take a look at the statement by her lawyers. And then if there are more of you that have not seen the entire hearing, we might go through the hearing again. I will ask when the time's appropriate, but let's look at the charges that got dropped as part of this plea agreement. That is the wrong screen, Emily. I wish I could share 2 screens. Miguelina, will you make a note and see if I can ask if we could ever share 2 screens or have them loaded so we had 2 screens? That would be so cool if we could just load them up. I don't know if we could do that, but if we could, I would like it. Alrighty. This is the original indictment or original information, apologies, against Ruby Franke. We're going to make this a little bit smaller. Count 1 is aggravated child abuse. All the counts are aggravated child abuse, but they are in different ways. Count 3 is she pled to count 3. Count 2 is the charge that was dropped. And that was that the defendant intentionally or knowingly inflicted upon the child serious injury, or having care and custody permitted another to inflict serious injury. And this was the malnutrition count. So it is going through the malnutrition count. So those are to victim 1, counts 1, 2, and 3, as to victim 2, counts 4, 5, and 6. She pled to 5 and 6. Count 4 was the malnutrition count. So the 2 counts that were dropped were counts relating to the children being significantly malnourished when the police interceded after victim 1 had escaped and gone to the neighbors for help. So Casey said, or is pleading guilty further protecting Jody? I don't think that Ruby is protecting Jody, and I will tell you why. Ruby, through her lawyer's statement, has thrown Jody Hildebrand as far under a dump truck as you can. Like, as the trash was being taken out, the dump truck has also run over Jody Hildebrand. This is what, or Brandt, Jody Hildebrand, Brandt, either way. This is what Ruby Franke's attorneys had to say. Ruby Franke is a devoted mother. Chat, her lawyer's statements, they are PR statements. They are PR. So just take a deep breath when you feel the rage bubble up. When you feel the anger, just take a breath. Take a breath. All together. Okay. Ruby Franke is a devoted mother and is also a woman committed to constant improvement. Initially, Ms. Franke believed that Jody Hildebrand had the insight to offer a path to continual improvement. Ms. Hildebrand took advantage of this quest and twisted it into something heinous. Over an extended period, Hildebrand systematically isolated Ruby from her extended family, older children, and her husband, Kevin Franke. This prolonged isolation resulted in Ms. Franke being subjected to a distorted, both, I think both are appropriate, distorted sense of morality shaped by Ms. Hildebrand's influence. During Ruby Franke's incarceration in Washington County Jail over the past few months, she has actively engaged in an introspection that has allowed her to reset her moral compass and understand the full weight of her actions. Ma'am, you are charged with child abuse, not theft. Like, what is the reset your moral compass? Okay. Ms. Franke is committed to taking responsibility for the part she played in the events leading up to her incarceration, demonstrating a sincere dedication to personal growth and rehabilitation. She has actively begun the process by reaching out to members of her family. Through heartfelt apologies, she seeks to mend relationships and contribute positively to the healing journey of her family. This is a statement that they are going to give also when they do the sentencing report, that she is seeing the errors of her ways or something. Ruby is aware that Kevin Franke has filed for divorce. While she is devastated by this news, she acknowledges and understands his anger and reasoning. Ma'am. Despite the pain, she respects his decisions and remains hopeful that with time, she can contribute to rebuilding trust and fostering understanding within her family. Go read your own probable cause affidavit, Ruby, and maybe you can understand where the trust has been breached while you were caring for the children, just maybe a little. Ruby has offered her full cooperation to help the children reunite with their father. Does pleading guilty help with that? I don't know if it will, but if the children don't have to testify in a trial against their mother, I cannot help but think anything other than that is a benefit for the children to start to heal from everything that they have been through. Winward law recognizes the profound love that Miss Franke holds for her children. They're doing their job. Emily, the lawyers are doing the job. The lawyers are lawyering. The lawyers are lawyering. The lawyers are... The lawyers are lawyering. And we are genuinely saddened that she found herself on this challenging path under the influence of Miss Hildebrandt. Ma'am, I am also a mom. And if somebody was like, you know what the best thing for your kids is? Withholding food, restraints, physical restraints, it's gonna be a fucking no for me. Like, it is our firm belief, or is it the belief of your firm, that Miss Franke is a devoted mother who unfortunately was led astray. There are some things you cannot be led astray into, but maybe that's just my moral compass. She is sincere in her commitment to securing the best possible future for her family and will remain hopeful that with the right support and understanding, she can navigate a path of healing and growth. She has blamed all of this on the devastating impact of Jodi Hildebrandt. And while we have seen others come forward that have talked about the impact of Jodi Hildebrandt, the people who have talked about that have been people who were under Hildebrandt's control and direction. Ruby Franke is an adult. But this is giving, she brainwashed me and there was nothing I can do. You are the mother. So do with that what you will. Yeah, that's quite a statement. That's quite a statement, isn't it? So we're going to go to some questions, and then if y'all are interested, we can always replay the hearing if you guys would like to see it again. Because why not? It's like 6 minutes long. We could do that. We can do that if we need to. Because we have time. Because why not? So it's the only place you're going to see the hearing at the moment, it seems. So we can do that if you guys want to. Okay. Let's go to Q&As real quick, and then we will play the hearing again. Look, we're going to take away new things each time we see the hearing. The PR statement is bad for my blood pressure. I mean, for all of us. We're all just like, breathe. 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 So for those of you just coming in, if you missed the beginning of the stream when I played the hearing, you would have known that I was streaming on a random day at a random time with random things. If you had the Lawnerd app. LawnerdApp.com will get you the free download of the Lawnerd app where I can keep you in the loop. So when you're like, hey, I didn't get my YouTube notifications, Lawnerd app. We've been talking about this all morning in the app. I've shared a quick short about what we were doing in the app. All that stuff has been shared in the app this morning. So if you are new here, yes, of course, do the like and subscribe things on YouTube. But other than doing the YouTube-y things, the Lawnerd app is a free app on iOS and Android, and it will absolutely let you know when I am doing things at unprecedented times because it's a holiday week. We're supposed to just have a Lawnerd Christmas party tomorrow, but here we are streaming this court hearing that nobody else has streamed just yet. Look at us. So, Lawnerds, thank you for making this the best place to watch live court coverage. I appreciate all of you, even when the statements are outrageous and we hate them. For the members, don't worry, I'll be recording the podcast later today, so we'll do that. Do you know the max time on each charge? B. Vargas, I do. It is 15 years on each of the aggravated child abuse charges, and they are charged under similar codes, same code section, different theories. Let's go look at the sentencing guide real quick. Because as I was getting ready this morning, did I pull that up yet? No. Let's see. Runkle's like, reset the moral compass. It's a very interesting statement, isn't it? So let us look at the Utah code real quick. Where is our subsection? So she is charged with which subsection? That's what I'm looking for. Why does it not say in the charging document? Point 2, which should be subsection 2. It should be a second degree felony. Based on what we're seeing, the aggravated child abuse, but it does not have the sentencing in the code. So it's going to take me a minute more to find this. I'll take a look while we're listening to the hearing, but the max time on the charges is 15 years. So that is what it is. I got the notification, but was modding on another channel. Just call me Hen. Don't worry about it. As long as we got the notifications, we're good. We understand it's a random day. We understand. We absolutely understand. So I'm going to get to some of the questions. JP said, what does stacking time mean? So when I said that these would be sentenced consecutively, not concurrently, sometimes consec and concurrent can be confusing. And some people are like, synonymous? No. Consecutive means they add to each other. So if a sentence is consecutive, the years add. So if it's, as a random example, because maths are hard, but if it's a 10-year sentence and a 10-year sentence and a 10-year sentence. So if you get 3 counts and you're sentenced to 10 years on all 3 counts, if that's concurrent, you serve your time all at the same time. So you serve 10 years and it serves a 10-year sentence for all of the fines. If you have that consecutive, you serve 10 and then your other 10 and then your other 10. And yes, that is apportioned down for any good time, work time that you would get, whether it is a 85% crime or a 50% crime. It's apportioned, but it's adding the time to each other. Carmen Does Stuff says 1 to 15 years and the fine for the second degree felony child abuse in Utah. Thank you, Carmen Does Stuff, which means the judge is going to be able to pick just about anything between 1 and 15 years, and those will be consecutive. So that's what's happening. Amy Miller said, distorted path is an interesting turn of phrase considering her teaching through connections was those who don't align with their teaching are in distortion. That is an interesting choice. Question, why would a judge, Robbie said, why would a judge refuse a plea? And we have talked about judges refusing plea deals. It's hard to give generalizations because law is very fact and individual specific, but there would be individual or fact specific things, or somebody would suggest a plea deal that is, outside the bounds of the law. So if there is a mandatory sentence and they were like, we would like to do a plea deal that's below this mandatory minimum, the court would be like, I can't sentence you below the mandatory minimum if the mandatory minimum is a shall. So there are legal reasons. And then there is a judge just saying, no, I'm not allowing you to plead to that. That deal's too high, too low, whatever. So it really is very fact specific. Evie said, if she's a loving mother, I'm a lawyer. I think I mean a lawyer, not just a law nerd. It's a very interesting statement for Ruby Franke. What if Jody pleads not guilty and has to go to court? Will all the Ruby stuff come up in that case? Carrie, if Jody Hildebrandt does not plead on the 27th, which I think she might, but if Jody Hildebrandt does not plea on the 27th, Ruby could testify against her. And part of the factual basis plea, we'll play this hearing again, but part of the factual basis plea is that all the facts have been admitted to. So Ruby has said these things happened. So if she testifies, she would have to be in line with that factual basis plea, or would be impeached with like, no, you admitted to these things. So could Ruby testify against Jody if Jody does not plea? Yes. But Jody has a hearing for waiver set on the 27th. I think that Jody will also probably plea. So we will see. All right, law nerds, I know that a lot of you came in late. Go ahead and do the YouTube things, and I will cue this up and we will play this hearing again. Sue said, thank you for streaming this important hearing or sentence, but we're not at sentencing yet. I suspected that they weren't going to be going into all of the details of this case and that we would learn more information from seeing the hearing ourselves, not just from reporting. And we have. So let's go ahead and swoop a doop and let's talk about what we learned in this hearing that we just did not know. We hear Ruby Franke make a very brief statement to the court before she takes her fourth plea. We learn that the sentencing will be consecutive, and we learn that the judge will not be hindered with a set sentence. Normally, when there's a plea deal, like in Murdaugh, we saw that he was pleading to X number of counts for 27 years. That was the agreed upon sentence. And even down to the fact that you heard Creighton Waters say, Your Honor, it's 10 years on this case or 20 years on this case plus 7 on this case consecutive. And then these other counts are running concurrent. So we saw that there was a negotiated sentence along with the plea agreement. Here, there's a plea agreement. 2 of the charges are being dropped. 4 of the charges have been pled to. The judge has accepted and entered that sentence. And the sentencing date after the pre-sentencing report is done will be on February 20th. And then the court will determine how much time in custody she'll get. So it's more like a federal plea where they agree on what charges will be pled to, but the judge will ultimately get to choose the sentencing. That answers my question. Thank you, Carrie. You are welcome. Thanks for asking great questions. Let us go through this hearing again. And if you've already watched it, you're going to learn something new because every time we watch a hearing, we learn something new. Which counts did she plead to? She pled 2 counts, 1 and 3 and 5 and 6. And we will go over that. I went over the document the last time, but the counts that were dropped were the counts regarding malnutrition. The other counts involved serious physical injury and serious physical injury that can cause severe harm. So it was 2 different types of charges. Is the pleading document public? Not yet. But if it gets filed in court today, I'm on the court's docket in the background. I will just have to keep checking in on it. I don't know if the court will make that public, but after we roll this hearing, I can definitely, or as I roll this hearing, I can check again. So let's do that. So.
Good morning. Welcome to District Court. We're here in the matter of State of Utah, Franke, case number 231501764. Mr. Winward is here representing Ms. Franke. Let's bring her out. And Mr. Clark and Mr. Sham are here representing the State of Utah. Ms. Franke is now here.
Oh, it froze. Apologies, y'all. That was on me. Sorry, you guys. That froze as I was trying to pull up the court docket.
Let's bring her out. And Mr.
That's a computer
Clark
quirk.
and Mr. Sham are here representing the State of Utah.
So I will have to do that after. The audio was still going.
Ms. Franke is now here. Mr. Winward, we are
I did not see
scheduled
Kevin in
for
court.
a waiver hearing. Is there going to be a waiver today?
There will, plus a plea agreement,
Didn't see Kevin in court. Didn't see any indication of Kevin walking into court, etc.
Your Honor.
All right.
I'll ask the bailiff.
The probation department or the jail department, depending on which department, but the whoever is in charge of custody is generally who does the pre-sentencing reports.
To hand you what has been executed.
All right. Mr. Winward, you have discussed with Ms. Franke a preliminary hearing, what's involved in a preliminary hearing. She understands she has a right to a preliminary hearing on all of the charges in the case. She understands what the charges are.
Cheryl, I'll answer that after this
A
hearing.
preliminary hearing in the case on
That's a
all
good
charges.
question.
She is, and that is contained in this agreement on page 7 as well.
Very good. All right. I've been handed a plea agreement.
Yeah, I'll
and
go
it
grab the
appears to be
pleading
signed
document
by
if
Ms.
it's up.
Franke. Ms. Franke, did you sign this agreement?
Yes,
I'll grab it
And
after
you
the
did that
hearing.
today? When did you sign it?
on the 18th.
Okay. You've read it carefully?
Every word.
Your signature represents to the court that you've read it carefully, that you understand what you've read, and that you agree to all of the terms. Is that all accurate?
Yes.
You've had sufficient time to ask questions of your counsel, to go over any questions you have. You're ready to go forward.
Yes.
You don't need any more time.
I'm ready.
Ms. Franke, is anyone pressuring you to enter into this agreement?
No.
Anyone promising you anything I haven't been told about?
These are the waivers.
Anything that's not in the written plea agreement?
No.
Are you under the influence of alcohol or drugs today?
No.
Is there anything today that could in any way interfere with your ability to understand the agreement, its consequences, anything?
No.
No physical condition, no medication, nothing?
No.
Any further record, counsel?
No, Your Honor.
We will go over
Mr.
the
Winward, we ready to
plea agreement
proceed?
afterwards. It is
We are
on the
ready
court
to proceed.
docket.
All right, then. Ms. Franke, how do you plead to count 1, aggravated child abuse, a second-degree felony?
Guilty.
To count 3, aggravated child abuse, a second-degree felony?
Guilty.
To count 5, aggravated child abuse, a second-degree felony?
Guilty.
And to count 6, aggravated child abuse, a second-degree felony?
With my deepest regret and sorrow for my family and my children, guilty.
There is a factual basis set forth in the agreement that is a stipulated factual basis, counsel.
That's correct, Your Honor.
That is correct.
Stipulated factual basis means that they have agreed to the facts that are being admitted as true. So in that stipulated factual basis, there are going to be more facts. That is now available on the court docket. So I will be going through that document next. I will be giving you guys a warning because if the stipulated factual basis is in there, it is going to have a tremendous amount of more detail about the ins and outs of these crimes. And some of that detail is going to be very, very unpleasant.
Correct, Judge Walton.
The court.
I've seen, Baxter, you're not the only one in the chat who's brought this up, that it's all second degree. That's what she was charged with. All of those charges that she was charged with were second degree. And I know that it can be challenging to wrap your mind around the things she's accused of being second degree felonies. However, in the realm of child abuse, are there worse cases than this? Yes. Are there substantially worse cases than this? Yes. Is that one of the reasons I do not like covering harm to children cases? Yes. There are cases where child restraint is a misdemeanor. So it might be the most appalling thing that you have ever heard of, but in the world of criminal justice, is this the most horrific case in this type of case? No. And that is why there are different degrees of this. But yes, all of the charges in the charging document when she was charged with child abuse, those are all second degree felony, not first degree felony. So I hope that helps understand. I don't want to get into examples. I will not get into examples. And that's where we're going to leave that. We're going to let this hearing continue.
Finds that the factual basis is sufficient. All of the terms of the agreement are stipulated, including that the court obtain a pre-sentence investigation report, correct?
Correct.
There won't be any argument about whether prison is the appropriate sentence, and there's an agreement about the 4 counts running consecutive.
That is correct.
They are agreeing to prison. They are agreeing that whatever the judge sentences her to, they will go after one another. So they will add to each other, not run at the same time. They will be consecutive. And they are agreeing to a factual basis, which means she is admitting to facts.
All right, the court finds then that Ms. Franke's pleas are made knowingly and voluntarily. The
These
court
pleas will
therefore
be after
accepts
the
and
report
enters
is done.
those
That will
pleas.
be in February.
The court orders the preparation of a pre-sentence investigation report to be prepared by AP&P and the Department of Corrections.
So for those that ask, the Department of Corrections is preparing it, which will help evaluate and assess where she will be housed when she goes to prison, because it seems like she will be going to prison. And they will help determine that and give some input to the judge about appropriate sentencing based on that factual basis plea.
Counsel, what about sentencing on February 20th? I think, do you and your client agree to waive time, counsel?
We do agree to waive time, Your Honor.
February 20th, I believe, is a Tuesday.
Some of you asked why so long for the sentencing report, given that it is a holiday week. February 20th is actually a pretty quick turnaround for a sentencing report. I know that in South Carolina, they're like, all right, we'll sentence you right now. Let's go. But those were agreed upon sentences, or sentences where there wasn't any other legal option. With the Murdaugh stuff, when he got convicted of the 2 murders, there was a legally mandated sentence. There's not a lot of options for the judge. It's like, you've been sentenced to this, your option is only that. Here, there is a lot more room. So the judge will need that report to start informing what they want to do on the sentence. So this really isn't a long time for sentencing, all things considered.
Is that right? Tw 10 a.m.?
That works for us, Your Honor.
All right. Anything else for today?
Your Honor, maybe, I've heard the court say this several times in a different fashion. We are not binding the court to any specific sentence, and the court retains its right to sentence as it sees fit. I just mentioned that this is not a Rule 11 plea, but although it's a stipulated statement of defendant.
Counsel, approach, please.
So they are approaching to chat with the judge. Tina, I saw your comment. Tina said, I wish I was the judge. I would deny this plea. Denying the plea means forcing the children to testify in a case like this. And I don't think any judge, especially any judge that has been on the bench for a substantial amount of time, would want to do that. If she is taking responsibility for 4 out of 6 charges, if they are agreeing to prison and a stipulated factual basis of the plea, it is a benefit to the victims in this case that the victims will not have to testify. I think that is a tremendous benefit for the kids.
Thank you, Your Honor.
Thank you. We are in recess.
Thanks, Your Honor.
And that is the end of this hearing.
Complete.
Judges are in court, depending on the judges. The judges are generally in court every single day hearing cases like this. The other stuff gets done after court, or at night, or at lunch. And that's the end of this hearing. Will the kids be involved in sentencing? Because there is a stipulated factual basis, I am optimistic that the kids will not need to give a statement at sentencing. So let us go through the plea agreement. This has the factual basis in the plea agreement. I am going to try to tone that down as much as I can. This has all the waivers in it. It has her signature in it. So we are going to go through as much as we can without getting into the facts. We will do any facts that are stated in it last. I will give a reminder again that we are doing the facts at that point. So anyone who would like to bounce on out of the chat for a little bit, you can. So let's go take a look at this stipulated plea agreement real quick. All right. Because the beginning of it's going to just give us rough information, which is very, very helpful. I need to be able to have 2 screens queued up for screen sharing. That would be helpful. All right. Here. So this is the little matrix that they've put together. Count 1, aggravated child abuse, second degree felony, 1 to 15 years in prison, a fine in the amount of up to $10,000 plus a 90% surcharge, and court fees of $53. So these are each count. Each count 1, 3, 5, and 6 are 1 to 15 years with the potential for the fine, with the surcharge, with the security fee. Court fees and fines can be substantial, to say the least. So the judge is not fixed on a sentence. So after the pre-sentencing report is done, the judge will fix a sentence for each of these counts. Could she get 1 year on each count? Yes. Do I think that's likely? No, I don't think so, but we will see. This goes through and lists again the counts. We're going to go through the waiver of rights. So this is the written waiver of rights. She's going to have initialed this and saying, I know what all my rights are, that there is, I know that under the Constitution, if I were convicted by a judge or jury, I'd have the right to appeal. By pleading guilty, I am waiving and giving up all statutory and constitutional rights explained above. No right to trial, no right to prelim, no right to appeal, no right to the presumption of innocence, no right to testify in your own defense, no right to confront and cross-examine witnesses. You are giving up all of those rights. Consequences of entering the plea. I know the maximum sentence that may be imposed for each crime to which I'm pleading. I know that by pleading guilty to a crime that carries a mandatory penalty, I will be subjecting myself to serve a mandatory penalty for that crime. So at least a year on each. So a minimum, it looks like, of 4 years. I know in addition to a 90% surcharge, in addition to any penalty, a 90% surcharge will be imposed. I also know that I may be ordered to make restitution to any victims. Consecutive concurrent. I know that if there is more than one crime, the sentence is imposed one after the other consecutively, which is what the judge has said. Plea agreement. My guilty plea is the result of a plea agreement between myself and the prosecuting attorney. All promises, duties, and provisions of the plea agreement, if any, are fully contained in this statement. Defendant agrees to plead guilty to count 1, count 3, count 5, and count 6. The state will dismiss count 2 and count 4. The defendant will submit to a pre-sentence investigation and adult probation and parole report. The defendant agrees to serve a prison term. The sentence received for count 1, 3, 5, and 6 are served consecutive after each other. The defendant agrees to testify truthfully against Jody Hildebrandt. In the return for the Washington County Attorney's Office agrees to remain neutral regarding future hearings before the Utah Board of Pardons and Parole. So if she's up for parole, they're not going to step in and be like, she shouldn't be paroled. But if Jody does not plea, Ruby will be testifying against Jody, which indicates to me that the state at least somewhat believes that Jody is a very, very big problem. So 6 is defendant agrees to testify truthfully against Jody. And then these are the rest of the rights that you are waiving. Trial judge not bound. I know that any charge or sentence, concession or recommendation of probation or suspended sentence, including a reduction of charges, made or sought by either defense counsel or prosecuting attorney, are not binding on the judge. So the judge is going to sentence Ruby to whatever the judge will sentence Ruby to. Deportation consequences, enhanced penalties for future convictions. If she's ever convicted again, this will come up. Waiver of preliminary hearing, acknowledgement of firearm restriction. Firearm restriction as a result of conviction or plea. These are all standard restrictions. Let's see. Defendant's certification of voluntariness, and this is her signing that she is 41 years of age and has attended school through 12th grade, and then understands that if I want to withdraw my guilty plea, I must file a written motion to withdraw my plea before sentence is announced. And that was signed today. Her attorney signed it today. The prosecuting attorney signed it when they typed it up on the 16th, and the judge signed it today. So with all of that, we are going to go through a brief basis of each of the counts. I will be doing this briefly. Again, replay crew, this will be timestamped down below. Should take about 5 minutes. I am not going to get into every detail that is here. That can be sought around the interwebs, but we are going to go through briefly what the prosecutors have laid out and she has admitted to. So let me pull this up real quick. Again, this is from the court's docketed website. From approximately May 22nd, 2023 to August 30th, 2023 in Washington County, Utah, defendant intentionally or knowingly inflicted or allowed another to inflict serious physical injuries upon her children that were ages 9 and 11 to 12, as more fully described below. And they have described each count and what goes to each count. So each count has more details than we have seen publicly before. So count 1, the defendant's action involved physical torture. Initially, victim 1, RF, was forced to do physical tasks for hours and days at a time, including wall sits, carrying boxes full of books up and downstairs, working outside, was forced to do outside labors without shoes in the summer heat, was forced to stand in direct sunlight for, it says, several days, was forced to remain outside at all hours and day of night for extended periods of time, which resulted in repeated serious sunburns with blistering skin, was denied adequate water for several days and was required to remain in the summer heat, and was punished when he secretly consumed water, was denied food, and was given very plain meals, rice and chicken, while others in the house ate regular or more flavorful meals, was isolated from other people in forms of entertainment. He ran away in July. His hands and feet were regularly bound. The binding included, and they talked about the different types of binding. I'm not going to get into the details of the binding. The binding caused serious physical injuries. The injuries were treated at home and then covered with duct tape, and then bound again to restrain that victim. Specific types of abuse, and this is physical abuse, included physical abuse, holding underwater, and other types of physical abuse while cutting off oxygen. Count 2 alleges that the actions caused severe emotional harm to victim 1, and then reiterate what things caused severe emotional harm, because of course they caused severe emotional harm. Additionally, the defendant and another adult, that's going to be the co-defendant, regularly sought to indoctrinate the victim and convince him that he was evil and possessed, that he needed to willingly be obedient to avoid punishment, and that the punishments were necessary to repent. He was told that everything that was being done to him were acts of love. With regard to the other victim, the defendant's actions also caused severe emotional harm to victim 2, EF, other than binding and specific instances of abuse that RF was subjected to, which were already listed and we kind of went through and tempered down. I know there's a lot of you that are like, this is horrific. We didn't cover everything. EF was subjected to the same treatment as brother. So the physical tasks, the outside, denied food and water, but was also told that she was evil and possessed, that the punishments were necessary for her to repent, that these things were being done to her in order to help her. And she, that victim, EF, was convinced that she was evil and needed to go through these things in order to repent. Let's see. The defendant's action caused 2 or more physical injuries to victim 2, EF, forced to work outside in the heat barefoot, forced to run barefoot on dirt roads for extended periods. Feet were repeatedly injured and sunburned. And then they talked about the nature of those injuries when these children were rescued, because victim 1 escaped and went to the neighbors. With everything they've been through, the fact that victim 1 was able to escape and go ask for help is absolutely an incredible sign of resilience. These children not having to testify about what their mother and Jody Hildebrandt did to them, I think, is a good thing. But these are the facts that Ruby Franke has admitted to as fact in her factual basis plea agreement. These are things that she did not deny were wrong. She said in her lawyers said in their PR statement that she was led astray. There are horrific instances of abuse here, but yes, these are second-degree felonies. So what they have left in this plea agreement was along the torture lines, causing severe physical and emotional damage to the children. So I understand the rage. I feel all of the rage. I get it. But I think the children not having to testify, at least against Ruby, is a benefit to them. We will see what the judge does at sentencing in February. And we will see what happens on December 27th when Jody Hildebrandt comes to court for a preliminary hearing waiver. Will Jody Hildebrandt plea? It's possible. Because it's very clear that Jody is going to get thrown under the bus by not just Ruby, but also Kevin. And we will see what happens. So, with all of that, we're going to finish up some questions, and then we're going to finish up streaming. Just a horrific thing. So, with all of that, let us get to our Q&A, our second Q&A. Jen Connolly said, it's even worse than I knew. I have tried to not go through every single detail of all of these. This I'm sure will be available and people will be reporting on every single detail of this. I think even what we've gone through is horrible enough for most people to be like, I'm out. That's horrible. It makes me sad that because of my profession as a district attorney, I can look at this case and be like, I understand why it's a second-degree felony. And that tells you a lot about the work that I tried not to do when it came to cases with kids, because I lose my objectivity when it comes to cases with kids. I'm like, nope. Ziggy said, I hope they both get the maximum sentence. Unlikely. It is unlikely that they will both get the maximum sentence. It is unlikely. And the reason it is unlikely is not only are these first offenses, and I know some of you are going to say, but this is a family vlogger and people have been questioning her methods for a long time. When I say first offenses, what I mean to convey is that this is the first time that they've been arrested and charged with these things. So when you are on a first offense and you have taken responsibility before trial, it's very, very unlikely that they will get the maximum sentence. So yes, I absolutely agree with you. Jennifer, Blue Coffee Cancer Girl said, will the judge allow her to have her children back? This judge will not get to make that determination. That will be subject to family law courts. What the family law courts will choose to do is something I'm not going to speculate on at this point. I will be interested to see what the sentence is and go from there. Will she ever be able to see her children again? I don't know. We will go from there. Will Jody's next appearance be televised? I don't know if the 27th will be televised, but I will be keeping an eye on that case. I imagine local media will cover it the way that this was covered today. Well, they will record it and then have the feed released. So unlikely. Yes. If you guys are hoping that they will get all of the time, I'm trying to set the expectation now that that they are not going to get 15 years on each count. The minimum sentence is going to be 4 years if they do the 1 year consecutive with credit for time served. That's going to be the minimum here. It doesn't look like they're eligible for probation. So from there, can you quickly explain a pre-sentence report? I am confused. Buttercup 203, you're probably not the only one. Pre-sentence reports are called a variety of different things, PSRs, PSIs, probation reports, but it is a report wherein the probation department, the Department of Corrections, or whomever in that jurisdiction is in charge of it, who will be taking custody of this defendant now that they have pled, will look at the police reports, sometimes interview law enforcement, sometimes interview victims and witnesses, interview the defendant's family, and give the judge a full picture of this defendant. This is the ins and outs of these crimes. This is what an appropriate sentence is. And we'll give a sentencing recommendation. So the pre-sentence report will look at different factors to give that recommendation, including the home life of the defendant, et cetera, et cetera. Will they take into consideration the statement of the defense attorneys? I would like them to. It's been made public. I would like them to. So we will see what is happening. Let's see. So, Opal Ducky, the way that the Utah law is written, because the restraint cases are not uncommon, where children are restrained by various methods. They are not very uncommon. So a lot of jurisdictions will put those types of restraint cases under the same, under the statutes that also encompass all different types of harm and abuse. So restraint going under the torture category is not unusual. So that is not unusual that law enforcement has described it that way. It is not uncommon. So I'm not going to get into that much more, just because I'm not here to break the chat. And I don't need y'all to need like secondary therapy based on my work experience. It's a lot. Some of my closest friends worked specifically in child crimes. So the amount of things that I've been exposed to versus the normal person or the average civilian that does not work in this area is different. And so I try to mitigate my my rage and my experience to acknowledge that when looking at this, if you have not been largely exposed to the criminal justice system on a day in and day out type of work, that this, when you look at it, you're like, this is the most horrific thing I've ever seen. Because I understand, because no one should be harming. People should not be harming each other. How about we just stop with that? But there's no reason. Harming children is unforgivable for me. So, I mean, there's a lot of things that are unforgivable, but harming children is at the top of the list of things that are unforgivable. So yeah, it's just a full stop for me. So let's get back into questions. Carrie said, what if Jody pleads not guilty and has to go to court? Will all the Ruby stuff come up in that case? Yes. And Ruby has agreed to testify against Jody, and the state is going to take that signed document right to Jody's lawyers if they haven't already gotten it from the court docket, if they weren't in court watching this happen. And Jody's lawyers are going to be like, ma'am, she is going to say that this is all your fault. This is what her lawyers have already said. The conversation that Jody and her lawyers are going to have about what Ruby did in court today and what Ruby's lawyers have had to say is going to be, they're all pointing the fingers at you. And if you're the last one going to trial, it's not going to go well for you. Yellow Pill said, as a survivor of child abuse, I appreciate when you guys cover these types of cases. I know it's not a topic many are willing to talk about. Initially, full custody was given to my abuser. I wish justice didn't take so long. Yellow Pill, I agree with you. Justice can absolutely be slow, but I hope there was justice in your case and healing for you as well, because it is a very, very difficult thing. If Jody refuses to, Elaine, I think you mean plead guilty, can the kids be called as witnesses in her trial? Yes. The children, if Jody goes to trial, the child victims will testify. Does that happen? Yes. Have people force their children to testify thinking they can make them back down while they sit in court and stare them down while they're on the stand? Absolutely yes. I just hope that with the distance and the time between going to trial and these instances of abuse happening, it gives the children time to heal so that they can testify. I also wonder if, because Ruby is their mother, testifying against Jody, who is just like the mom's business partner or whatever, might not be quite as difficult, because that is not your mother. So do I think they will let Jody plea? If Jody wants to plea, I think they will. I think Jody will plea. If Jody wants to plea, I don't think there's a reason the state would say, no, you can't plea. Again, these are first offenses, and I have rarely seen prosecutors force particularly child victims, to testify if the defendant is willing to plead to something that is reasonable. Now, if the defendant has multiple cases spanning lots of years on the same types of crime, if the victim is like, yeah, I'll plead, but for one count and, probation, things like that, I've definitely seen prosecutors be like, no. But when the defendant's like, okay, this is reasonable, and the prosecutor's like, yes, this is reasonable, do I think they won't let Jody, they would force Jody to plea just to see if they can get more time after trial? No, I don't think they would put the victims through that. There's no reason to. But we'll see what happens on the 27th, won't we? So, question: Jody Hildebrand has a history of abuse as a therapist. Can that history be brought into trial by the prosecution? Mariko, it very much depends on what. It is my understanding that she has never been charged criminally, but if there were ethical investigations and things that were documented in that way, could that type of character evidence come up? It can, but it depends, and it's all going to be subject to quite a lot of evidentiary hearings because those are prior bad acts, and that prior bad acts evidence would go through all of those kind of motion in limine 402 hearings before trial. So I hate saying it depends, but it is very factually specific to a case, and the way that those things have been reported and investigated matters. So that. Let's see. Are we there yet? So Jody has used religion as her excuse. Do you see this brought up as an excuse if there is a trial? Again, like we saw in other trials dealing with mostly Scientology, it will really depend on if that needs to come up to explain things or if Jody testifies. But it's going to very much depend on how the evidence comes in. Because right now, the case is evidence of child abuse. The state doesn't need to say or provide a reason this was done. All the state needs to show is that this was done. There's no other information necessary. In a case like the Masterson case, there was delayed reporting, and part of explaining victim actions were explaining the circumstances and the religion that the victims were in. And that was part of why the prosecution fought to bring it up, to help explain things. There's not much here that needs to be explained, for sure. So let us continue on. Can you plead but not admit the facts? Aaron, generally with a guilty plea, you're admitting that you did the crime, but not every guilty plea lines out a factual basis. That's going to vary by case and by jurisdiction. So can it happen? Yes. Is it going to happen in a co-defendant case where the co-defendant hasn't pled yet? No. Irish Eden said, thank you, Emily and Lawnards. I prefer to only go through this kind of cases with y'all. Safest place for triggering cases. I try my best, and I do not regularly cover these things on live stream. I generally leave it to the podcast. And I try to make sure that we are not diving into every single detail. If this goes to trial, will I be covering a trial live? No. Sentencing hearing, yes. Plea hearing, yes. We're going to get less into the details with it. What are the sentencing guidelines for each count? We went through that a little bit. This probably came in before we did that, but it is 1 to 15 years in prison for each count plus a fine. Kelly D said, what does this mean for Jody? We'll see if Jody pleads on December 27th or not. But if Jody does not plea and goes to trial, Ruby will be testifying against her. Line said, thanks for this distraction on a heavy day. You are welcome. Neither she nor Kevin deserves those kids. They together will see. Casey Cat, he was not charged. And I don't think that he will be. Chris said, what's the maximum time she can get? I don't think she's going to get the maximum time, but if they ran 15 years by 4 consecutively, what's 15 by 4? I'm sure the chat will tell us that. It could be that. Thank you guys for your membership. Hildebrandt was influenced by a book. I don't know the book, but I think you were indicating a book. Good to see you, everybody. Can the PSI reporter take into consideration her old videos? Generally not. Thank you all. 60 years. Which is, that's not going to happen. Can the PSI reporter take into consideration her old videos? Not if they're not in evidence. However, what's in evidence in the case file can be taken into consideration. We just don't know what's in evidence in the case file. Baby Step said, I get it, Emily. I work as a public health nurse in foster care medical case management. I've had to read horrible medical records of this type. I am sorry. And of this type and worse. I am sure it is a very hard job to do. And I don't want to just ruin everybody else. Like, sometimes you choose not to know, and that's a good thing. There's times when I'm like, don't Google things. Just because sometimes you don't know what you're getting into. And once things are seen and known, they cannot be unseen and unknown. Frankie said, I remember very vaguely the court having someone I spoke to that spoke on my behalf. Is that the thing, or am I misremembering? It depends on the circumstance and the case. But yes, there can be guardian ad litems. There can also be victim service representatives and different types of victim advocates who can give statements on behalf of the children at sentencing, but in the US, not at trial. So at different hearings, yes, but at trial, there is a Sixth Amendment right to confront your accuser and to confront witnesses against you. And if the witnesses against you are children, the witnesses against you still have to come to court and testify at a trial environment. But that is not the same at sentencing. Those statements can be given by a variety of different people. And remember, there are still family law cases going through the process that are private. So we will see what happens there. Are Jody and Ruby in jail together? I love that you cover this type of case so delicately. I do my best to inform without sensationalizing, because I find the sensationalizing of, a lot of criminal cases to be gross. So there's that. Are Jody and Ruby in jail together? I mean, they are both in custody. How closely together they are kept, I have no knowledge of. So, Tammy, I'm so sorry. I lost my house in a fire in October and received my I Have Questions hoodie today. Thank you for being a bright spot. You are welcome. Can we share a GoFundMe link for Matt Bond? Matt, do you have a GoFundMe? Will you just message me? For the record, on the record, let the record show, hello, my spiffy legal mumbo jumbo talkie sister from another Mr. Good to see you, Matt Bond. It is heavy stuff. How is it decided whether to sentence concurrent versus consecutive? Oh, Christy. There are so many different factors that get taken into account. I don't think I can succinctly answer that. It is fact specific. It is case specific. It is defendant specific. And in some cases, it can be legislated that things go concurrently. So there are things that go concurrent and things that go consecutive, but how you determine that is very, very fact specific. I wish I had a better answer. There's no formula for that. Boffel said, I used to provide mental health services to inmates. Co-defendants cannot be housed together or communicate. So yes, on what in jail means, are they housed in the same jail facility? I don't know. Are there as many female facilities as male facilities? Generally not. But yes, Boffel Waffle, I very much appreciate that. They will not be like roommates. That is true. So question, have you ever had a case where the parties threw around allegations like, I'm not sure what you mean by throw around allegations, Tom the Cat. I'm not trying to be picky. I just truly don't understand. But have I seen cases with allegations like this? Yes, and worse. I very much tried not to prosecute cases where kids were victims. I found it hard to be objective, but particularly in juvenile court, these types of fact patterns came up if the juvenile was also arrested for doing something else. So we would have juveniles arrested for stealing clean clothes, like ripping open a bag of socks in a Walmart and taking out one pair of socks because they didn't have clothes. They ended up getting arrested for the stealing of the clean clothes, and then everything was uncovered. So have I seen cases like this? Yes. Did I try not to prosecute cases where adults were doing these things to children? Yes. Law and Crime just posted a video that Ruby pled guilty. We just covered it twice. Buttercup said, you seem sad covering this today. These cases make me sad. I don't like them. They make me sad. I think it's important to cover them without sensationalism. I think it's important to cover them factually. I think it's important to talk about them. I think it's important to cover them in a way where the community feels respected and protected. But I do not like them. No, don't like them at all. So it's there's a lot of rage. It really, really makes me angry. These cases make me angry. So yes, if I come across as I am sad, yes, it's because it makes me angry. These children have been through quite a lot. However, they will not have to testify against their mom, and I think that that's a good thing. She will be spending some amount of time in prison, and I think that that's a good thing. We will see how much time that is. It's going to be frustrating. For some of you, there's not enough time in the world. You're like, all of the time. So no matter what amount of prison she gets, for some, it's never going to seem like enough. And I get it. I absolutely get it. It's very, very frustrating. Corey said, can Ruby and Jody talk in any other way? No. Letters? No. They can't call each other. No, there's no way they can communicate. Can they communicate through their lawyers? They shouldn't be. And their lawyers are at odds with each other because Ruby's best defense is Jody did this, and Jody's best defense is she's their mom. So they're not co-defendants that are working together. So that's it. Dells said, how can you read the plea agreement? I'm sure somebody has already posted it on the internet. I have not looked because I've been live streaming. Completely understand and empathize with your anger. Children should never have to go through these things. I mean, at the end of the day, when I look at the criminal justice system, I'm like, could we just not with each other? Could we just not do the things to each other? So let's see. Question, do you think Ruby has changed her mind moral compass? I don't know. I don't know. I don't know Ruby Franke. I don't know her. I don't know her. I don't know her videos. I've never watched her content. I don't know. So I don't know if she has changed. I don't know if it's genuine. I don't know if she's just absolutely scared to death because she is going to prison. I don't know. So we will see. Ruby and Jody are both monsters, but Ruby is the mother. Ruby is indeed the mother. And you saw in these charges when I went through them on the podcast that allowing someone else to cause harm, you can also be charged. I've talked about that in a couple different podcast episodes. Vicky said, why is YouTube not being punished for not keeping an eye on these channels? YouTube is protected by Section 230. I have talked about Section 230 and other content, taking it out of YouTube, but other platforms, because the stuff that is, taken down off of platforms, but the stuff that is allowed to go up on platforms is not YouTube specific. This is any platform specific, but they are protected on user-generated content by federal statute. When was the last time I covered Section 230? God, it's been a minute. But YouTube, when they find people violating terms of service, sometimes take things down and sometimes don't. But there is federal law that allows for publishers to protect, to be protected, not publishers, hosts to be protected. It was written in 1996 when you were just starting to get like listservs and stuff. And it was generally in the telecommunications world, like if somebody communicates a threat over a telephone line, can you go to AT&T and be like, this threat was communicated, I'm suing you, AT&T? No, because they're not the one doing the thing. They're just hosting the thing. So it is a very large conversation about Section 230 and the ins and outs of Section 230. Lynn said, who will take care of the children while she is in jail? There is a ongoing custody case. They have an adult sibling. I So who is taking care of the children at the moment? I don't know if it is the adult sibling, but they were in the care of the state for a little while after this happened. But they do have an adult sibling outside of just their father. They also have, aunts and uncles, and I believe grandparents. So that is for the family law to decide. Kate P. We talked about this earlier during the hearing. So just to reiterate, these will be consecutive sentences when sentencing happens in February. 230 immunity, which is the Communications Decency Act 230 immunity, except FOSTA, SOSTA. I was trying not to get too much into the nitty gritty, Nikki Canyons, thank you, of Section 230, because we would end up here for another 3 hours, and I still do have to record the podcast. Will they serve time in the same prison? Carol V, there's too many unknowns for me to answer that question, but we will see what happens. They will be sentenced to state prison. I don't know how many different state prisons Utah has. I did not work in the Utah prison system, so I do not know how many different prisons Utah has. Thank you for live streaming today. I'm having artificial disc replacement tomorrow, and you're taking my mind off surgery. Well, glad to take your mind off surgery. Tomorrow is the Leonard Christmas party. Trophy Wife said, where was the husband? I've covered that in the Emily Show podcast. I think others have also covered it, but he was living apart from Jody while Jody was living with, he was living apart from Ruby while Ruby was living with co-defendant Jody while this was going on. So Deb said, if there's any justice, she'll at least be in prison until the children are adults. We will see. I mean, that would, how old is the youngest? That would be upwards of 10 years, 9 years. The youngest is 9. So we will see. Ashley D said the Heather Elvis case is 10 years old today. Her case was my first watch live on YouTube. It opened the door, and now I'm a Leonard. There we go. B2, did you read it? Did you understand it? Did you sign it? I mean, plea hearings can go pretty quickly. Why so long for the report? I know we talked about that a little earlier. This PSR is actually coming in pretty quick. I know others in the chat said they're normally 90 days. They normally take quite a while, and I know we covered that. Question, why would the prosecution offer agree to a plea? Does it benefit them in some way? Cheryl Reed, it's a great question. Yes. A, they don't have to take the taxpayers' time and resources to go to trial on this case. B, they don't have to have the victims and the victims' siblings come in and testify against their mother, which is a huge benefit. C, they are allowing this case to kind of close and move forward, and allowing everyone involved to start to move forward. I think there are other benefits to them than that, but there's also no appeal process. Like, once you've pled and been sentenced, it's done. She goes to prison. This case is closed and on, unfortunately, to the next one, because there is no shortage of cases to be prosecuted. So that is some of the benefit there. And also, if a defendant is willing to take responsibility, it is generally something prosecutors will allow them to do, except in cases, especially homicide cases, where it's like, well, if you don't want to plead to life without parole, then there's nothing to be done. But that's the rarer circumstance. That's generally the rarer circumstance. Do we know anything about this judge? I don't. I have not looked into this judge very much. This case has been very, very quiet on the docket. There was the initial arrest. Then there was the defense attorneys initially put onto the docket an expedited bail hearing, and then those bail hearings came off the docket. And then it was very, very quiet till now. So Tickled Pink Music said, question, isn't the malnutrition worse? Why did they drop those? All of the cases are under the same code section with different variations of the same code section, each of the charges, each count. So I don't know how to apportion worse, but what was pled to was the serious physical injury, involving torture, and the fact that serious physical injury caused serious physical injury and psychological injury. So isn't the other worse in the eyes of the court? I don't know, but they chose to drop 2 counts. It's not to say they couldn't have proved it, but it's because that's what they chose to allow people to plea to. I think courts can wrap their heads clearly around serious physical injury, and I think that malnutrition can come up within that. So I think it's all accounted for. So hopefully that helps. Let's see. Bree, it's okay. Bree said, haven't been able to make it live in so long. Miss all my law nerds. Well, glad you were here today. It's a rare Monday stream, and it's a tough one. So with all of that, members, I see all of your member chats. I'm sorry if I don't get to all of them. I still do have to record the podcast for today. We have lots to do before I take a break for the holidays. Are we ready to take a break for the holidays? Yes. B2, thank you so much for the kind words. It's good to see you in the chat. It was good to see you in our Zoom call. So let's see. Sarah, this is accurate. Jody is going to court for a waiver hearing on December 27th. Ruby was on calendar today for a waiver hearing. Does that mean Jody will plea? Maybe, maybe not. Does that mean Jody will waive her preliminary hearing? Probably. So we will just have to wait and see what happens. Matt Bond said the kids will never escape this thanks to the internet. The last thing they need is to tell it again. Even given 4 years, Ruby will never get past this. I think it's going to be very hard for the kids, but people are able to overcome their past. I hope that the kids are able to overcome the things that were done to them, and whatever that looks like, for them to move on and heal. I hope that people allow them to. So with that, I am going to question, is tomorrow the last Law Nerd Live? Well, not the last forever, Stephanie, but yes, tomorrow is my anticipated last live stream for the year, for some much needed time off and time with my kiddos, and downtime with the family. So yes, tomorrow is anticipated the last live stream of 2023. I will have a new podcast out for you that covers this a bit more succinctly, and some of the new Donna Adelson stuff on Wednesday. And then we will be taking a little bit of time off over here at the Baker House, and I am very excited about it because we will hang out. I totally screwed up my Pokemon Go sleep last night. I am still not able to put it aside. Emily, it is a digital sleep game. But my tale of woe is long, and I am salty about it. Real salty about messing up my Snowdrop Tundra Sunday night of sleep. I am salty. So with all of it, I am going to take a little bit of time off over the holidays. I will be keeping you updated in the Law Nerd app first. If there is a hearing that we need to cover with regard to Jody, I will keep you updated there first. New podcast on Wednesday, and then it is the holidays. So for all of you, wherever and whatever you are celebrating and however you are celebrating, I hope it is a good one and a restful one. It is what we all need. JP, congratulations on your graduation. Law Nerds, thank you for being here. All right, I graduated yesterday. Cheers. I'm glad I inspired one of your papers on tax code can influence purchasing behaviors. It was interesting research. I'm so glad. The tax code is behavioral manipulation. Discuss. For another day. Law Nerds, thank you. It is good to see you. I know it is a heavy topic. I hope that I answered your questions. And I will see you soon. Thank you for continuing to make this the best place to watch live trials. Because, it is. I'll see you guys in the next one. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.